Please rise for the arrival of the Lieutenant Governor. You may be seated. Good evening, Lieutenant Governor Murphy, Chief Justice Richard, Chief Justice DeWare, members of the Judiciary and Bar, university officials, Wikadajimid, faculty, staff, students, and alumni of UNB Law, and of course our distinguished Viscount Bennett Lecturer, the Right Honorable Richard Wagner, Chief Justice of Canada. My name is Michael Marin, and I'm the Dean of Law at UNB. I'm absolutely thrilled to welcome you all to the 42nd Viscount Bennett Memorial Lecture. We respectfully acknowledge that UNB stands on the unsurrendered and unceded traditional Wolastoqey land. The lands of the Wabanaki people are recognized in a series of peace and friendship treaties to establish an ongoing relationship of peace, friendship, and mutual respect among equal nations. The river that connects our two campuses is known as Wolastoq, along which live Wolastoqey, the people of the beautiful and bountiful river. Wolastoq is also called the St. John River. This is a very special day. It comes 2 years after our faculty, like so many across Canada and around the world, was forced into isolation by the pandemic. But the effects of this worldwide event were particularly upsetting for UNB Law. And that's because we're an intimate and friendly community of law students, professors, and staff who thrive on being together. And when COVID-19 moved our courses online and made events like this impossible, we lost an important part of our identity. And when a community loses one of its defining characteristics, coping with crisis and uncertainty is all the more challenging. But things are returning to normal. And this evening, we're together again for the first major event in the law building since 2020. Monsieur le juge en chef Wagner, merci d'avoir fait du Nouveau-Brunswick et de UNB Law votre première visite officielle depuis le début de la pandémie. Votre présence nous a tous réunis et nous sommes très fiers de vous accueillir à notre faculté de droit. This is the first time that a sitting Chief Justice of Canada will deliver the Viscount Bennett Lecture. The lecture honors the life and civic contributions of R.B. Bennett, a native of Hopewell Hill, New Brunswick, and lawyer who served as Canada's 11th Prime Minister from 1930 until 1935. As Prime Minister during the Great Depression, Viscount Bennett led our country during one of its most challenging periods. He established agricultural marketing boards, the CBC, and the Bank of Canada, institutions that endure to this day. Bennett is the first and only former Prime Minister to be elevated to the peerage of the United Kingdom, becoming Viscount Bennett of Mickleham in the county of Surrey and of Calgary and Hopewell. Bennett was a lifelong friend of Lord Beaverbrook, a major benefactor of our faculty, the university, and the province. Since 1975, the Viscount Bennett Memorial Lecture has featured distinguished jurists from Canada and around the world, including 8 judges of our Supreme Court. This event is overseen by a faculty committee, co-chaired by Professors Anne Laforêt, QC, and Jane Thompson. I'd now like to invite Professor Laforêt to formally introduce Chief Justice Wagner.
Thank you, Dean Marin. Good afternoon, everyone. As the co-chair of the Speakers Committee at the Faculty of Law, I have the distinct pleasure to introduce our 42nd Viscount Bennett Lecturer, Chief Justice Wagner of the Supreme Court of Canada. The Chief Justice was appointed to his current role on the 18th of December 2017, shortly after the retirement of the Right Honourable Beverly McLaughlin, who during her time on the court also delivered this lecture in 1989. After obtaining his law degree at the Université d'Ottawa, Chief Justice Wagner began practicing law in Montreal and continued to do so for almost a quarter century. Chief Justice Wagner was appointed to the Superior Court of Quebec in 2004, the Quebec Court of Appeal in 2011, and then to the Supreme Court of Canada in 2012. As his biography discloses, he's been particularly passionate about access to justice. And in this context, I might say access to the law itself in the form of his focus on plain language projects. As the Dean noted in his remarks, this lecture has been a long time coming. The original invitation was made a short time after the Chief Justice's appointment, and in the midst of what must have been an avalanche of such requests, he very generously agreed to come here. But as I often say to my students in my course in private international law, a funny thing happened on the way to the forum. The pandemic, which has been an international, federal, provincial, and municipal issue, has aggravated the normal scheduling difficulties that accompany this event, but here we are now finally. The topic of the Chief Justice's lecture today is Reflections on the Diversity of Legal Traditions in Canadian Public Law. And as I was preparing this introduction, it struck me that the Chief Justice of our country is in a unique position to consider and opine on the subject because it brings an almost daily consideration of the topic, given that almost every significant public law case in such areas as constitutional law, Indigenous law, administrative law, criminal law, and international law wind their way to that highest of our courts. And in this role is perhaps more critical during times of transition or of crisis of the kind we have been facing these past 2 years. In his remarks, the Dean commented on the namesake of this lecture, Viscount Bennett, and as he mentioned, he was the Prime Minister during what remains, at least to date, our most serious economic emergency, the Great Depression. The Chief Justice at that time was Lyman Poor Duff, who was appointed to the court in 1906 and nominated by Viscount Bennett to the position of Chief Justice in 1933. He retired in 1944, and his tenure saw the development of such matters as the framework for the division of powers and our emergence as an independent state in the world. His time as Chief Justice ended just shortly after the end of appeals to the Judicial Committee of the Privy Council, a council of which he was a most distinguished member. I mention all this because, to my mind at least, his most significant decisions, and the ones that involve deep consideration of a diversity of legal traditions, were those references that came before the court at the end of Viscount Bennett's period as Prime Minister, and they related to legislation intending to deal with the economic harms of the crisis of the Depression. These decisions addressed such issues as social security and conditions of work that had been established in international treaties and ultimately led to the framework for both cooperative federalism and our approach to international law. I make the connection now that there's no doubt that Chief Justice Wagner and his court will continue to play this important role, and while he's been in the position only a short time relative to Chief Justice Duff, we can already see this. In preparation for today's lecture, I asked a few of our colleagues to provide a few examples. And as an international lawyer, I am particularly interested in the decision of Nevson and Araya, a 2020 decision in which the court clarified the customary international law and jus cogens and its use in our domestic law, which is something I'm very interested in. And an interesting aside, actually, is that Justice LaBelle gave the 35th Viscount Bennett lecture, which was very much a source and concerned branch of Parliament's peace order and good government power. And beyond constitutional law doctrine, the decision is very significant because it upheld one of the most important policy tools for responding to the crisis of climate change. I think anyone who's read this decision and Chief Justice Duff's decision in the Labour Convention's case might see kindred spirits in their thinking about the law. I might also mention Ward in Quebec, a decision in which Chief Justice Wagner provided a very staunch defense of freedom of expression in the context of comedy alleged to be discriminatory. The reasons provide guidance on how to resolve conflicts between dignity and free expression, guidance which will be crucial for protecting and promoting dialogue in an increasingly fractured public sphere. And finally, I'd mentioned Toronto and the Attorney General, which deals with foundational issues of our constitutional structure of government. That case addressed the constitutionality in reducing the number of Toronto's wards from 47 to 25 after a municipal election. The majority, written by the Chief Justice and Justice Brown, held that unwritten constitutional principles do not confer upon judges the power to invalidate legislation that does not otherwise infringe the Charter, nor do those principles limit provincial legislative authorities over municipal institutions. Those cases are certainly a beginning, but I know just that. And I would ask you to join me in welcoming our 42nd Viscount Bennett lecturer. Welcome, Chief Justice.
Well, good afternoon to all, and thank you so much, Professor Laforêt, for your kind introduction. Thank you also for the invitation to present the Viscount Bennett Memorial Lecture. I am very, very happy to be here this afternoon with you, and it's a real privilege for me to be here. As Dean Marin mentioned, the Right Honourable Viscount Bennett led Canada through some of the most challenging years of the Depression. He did so with courage and determination. As an elected official and later Prime Minister, he also helped put social policies and institutions in place. These include the Bank of Canada and the CBC, which continue to serve our country today. He also hoped, through this lecture series, to promote a greater appreciation of the law in contemporary Canadian society. I am pleased to be part of that effort because I agree that the law plays a very important role in society. Je suis ravi de le faire ici, à l'Université du Nouveau-Brunswick, où tant de distingués juristes ont amorcé leur carrière juridique. Le nom de l'honorable Gérard Laforêt figure, comme vous le savez, sur la longue liste des éminents diplômés de cette institution. Le juge Laforêt m'a précédé au sein de la Cour suprême, mais sa jurisprudence continue, à ce jour, d'influencer les travaux de la Cour et elle continue d'influencer la société canadienne en général, tout comme le fait l'œuvre du vicomte Bennett à d'autres égards. In these uncertain times, I have been thinking a great deal about the role of the law. On the morning of March 15th, I was sitting in the House of Commons when the Ukrainian President, Mr. Zelensky, addressed parliamentarians. The House of Commons was absolutely silent as he asked Canadians to imagine bombs falling on our cities and our homes. The President said, and I quote, "We're not asking for much. We're just asking for justice," end quote. Indeed, under the most horrific conditions, the Ukrainian government has sought a legal means to end the violence. For example, it has taken Russia to the International Court of Justice, ICJ, even when Russia did not show up for the hearing. Ukraine said it still had faith in the law. At the end of that court proceeding, the ICJ ordered Russia to stop the invasion, but as we all know, it has not stopped. Yet again, Ukraine said it still believed in the importance of the rule of law. That conviction inspires me and gives me hope for the future. We can all play a part in making the future better, which is the spirit of this lecture series. After all, it is not just for the courts to uphold the rule of law. Everyone can play a part. How? Well, take the time to share your knowledge about Canada's laws and legal system. Learn how to identify and stop the spread of misinformation and disinformation. We have seen how the spread of lies, even half-truths, can threaten democratic institutions around the world. In Canada, our courts are open, impartial, and independent. Our justice system is strong and stable. These make up the foundation of a healthy democracy, which is something we should never take for granted. We are lucky to live in this country. Canada may not be an economic or military superpower, but it certainly is a democratic superpower. And we like to share that power. We did so, for example, with Ukraine. For many years, Canadian judges and staff from all court levels have worked closely with Ukrainian judges and their own staff to help them improve their judicial system. For example, we have helped them improve their processes for the selection and appointment of judges, for managing conflicts of interest, for processing cases, and even for judgment writing. Once the invasion ends, we will still be there, standing with Ukrainians to help them restore their judicial system. Canada can indeed be proud of its laws and legal institutions. They reflect the diversity of its people, as well as their different legal traditions. This includes the common law and civil law, and even longer-standing Indigenous traditions. Canadian law is also influenced by international law. I would like us to consider this diversity of legal traditions together this afternoon. I propose to review some cases from each of these sources to explain how they influence one another. All of these cases will be different. I will start with a common law case where the civil law concept of good faith was considered. I will also explain a case involving an Aboriginal title claim. And I will end with a lawsuit that Professor Laforêt mentioned in her introduction, the one against the Canadian Mining Company for violations of customary international law. You might think that these cases have nothing in common, but they do. They all demonstrate how Canadian law has many sources. Let me pause here to make a quick point. I will be referring this afternoon to Indigenous law. By this, I mean the law developed by Indigenous peoples. Through history, Indigenous and non-Indigenous peoples maintain their own legal traditions. But with time, legislative drafters began to recognize more than one legal tradition. We can see two legal traditions reflected, for example, in the enabling statute of the Supreme Court of Canada. Being a court of appeal for the entire country, the Supreme Court is responsible for deciding some cases according to the common law and some according to the Quebec civil law. The original Supreme Court Act required 2 of the 6 judges of the court to be from Quebec. As the size of the bench grew, so did the number of judges from Quebec. There are currently 9 judges on the court, 3 of whom are from Quebec. This ensures both common law and civil law representation on the court. The Constitutional Act of 1982 is another example of legislation that recognizes more than one legal tradition within Canada. When it was adopted, it provided constitutional recognition of Aboriginal and treaty rights. Section 35(1) says explicitly that Aboriginal and treaty rights were being recognized at the time. In the decades since 1982, the Supreme Court has also recognized the importance of Indigenous perspectives on the law in its Section 35 jurisprudence, particularly in areas directly applicable to Indigenous peoples. With the Constitution Act of 1982 came the Canadian Charter of Rights and Freedoms. The Charter is inspired by various international treaties, including the Universal Declaration of Human Rights and International Covenant on Civil and Political Rights. It is perhaps no surprise that the influence of international law has been especially noticeable since the Charter. We can see the influence in both the case law and federal legislation, including in international trade, taxation, maritime law, environmental law, and other areas. Today, Canadian lawyers and judges increasingly draw on civil law, the common law, Indigenous legal traditions, and international law. As a judge of the Supreme Court of Canada, and now as Chief Justice, I can see this firsthand. As I mentioned earlier, the court is composed of judges trained in civil law and others in the common law. In our exchanges, we often draw from both legal traditions. Also, we will often hear submissions from parties and interveners trained in either or both traditions, or trained in Indigenous legal traditions, or even practicing international law. They provide us with perspectives from these various legal traditions, which are very helpful when they differ from the law in force in a given case. Drawing on these different perspectives and applying them where appropriate can inform a legal issue. It enables my colleagues and me to consider perspectives developed by all the people we were appointed to serve. The existence of different legal traditions is one of the strengths of the Canadian legal system. It allows us to draw on more than one perspective when addressing a legal problem. Let me now explain how the Supreme Court of Canada has done this in different cases. I will begin with a case decided under the common law, but in which the Supreme Court considered civil law sources from Quebec to resolve the matter. It was the Callow Case, which was decided by the Supreme Court in late 2020. The case came up from Ontario. For those who do not know the facts, let me explain them briefly. In 2012, a condo corporation called Baycrest entered into a 2-year winter maintenance contract and a separate summer maintenance contract with a company owned by Mr. Callow. According to clause number 9 of the winter contract, Baycrest could end it if Mr. Callow did not provide good service. It could also end the contract for any other reason by giving Mr. Callow 10 days written notice. In early 2013, Baycrest decided to end the winter contract, but did not inform Mr. Callow. Throughout the spring and summer of 2013, Mr. Callow and Baycrest discussed the renewal of that contract. From those discussions, Mr. Callow thought that Baycrest was satisfied with his services and was likely to offer him a 2-year renewal. During that time, Mr. Callow performed work above and beyond the summer contract at no charge. He hoped that this would convince Baycrest to renew the winter contract. But in the fall of 2013, Baycrest told Mr. Callow that it was not renewing it. Mr. Callow sued, alleging that Baycrest acted in bad faith. The trial judge sided with Baycrest, but then the Court of Appeal sided with Mr. Callow. A majority of the Supreme Court agreed with Mr. Callow. Justice Cassirer wrote for the majority and said that Baycrest breached its duty to act honestly toward Mr. Callow. As Justice Cassirer explained, the duty of honest performance did not require Baycrest to tell Mr. Callow that they would end the contract early, but it did require the company not to mislead him. Even though this case was decided under Ontario law, the majority of judges considered civil law sources from Quebec. While the requirements of honest contractual performance in the two legal traditions have distinct histories, they address similar issues. So looking to Quebec law can be very helpful. The court has often done this over the years, not just in appeals from Quebec or in matters relating to federal legislation. The Callow case is a good example of this. It is from Ontario and does not relate to federal legislation. Just remember that this exercise is not limited to cases where there's a gap in the law. As Justice Cassirer wrote in Callow, not considering solutions from other legal traditions would limit the court's ability to understand how problems are addressed elsewhere in Canada. What do you think? Is there any downside to considering helpful material from any other legal traditions? Let me now turn to Indigenous perspectives and explain how they too have informed legal issues. I will be taking Aboriginal title as an example to illustrate this example. Aboriginal title refers to the exclusive right to use a particular territory. This concept has become important in Canadian jurisprudence. But the story began almost 50 years ago with a Supreme Court's decision in Calder. The appellants were asking the court to declare that their Aboriginal title had not been extinguished. Although they were unsuccessful, all of the judges on the court recognized the possibility of the existence of Aboriginal title. In the years since Calder, there have been other cases where the Supreme Court has discussed Aboriginal title. In Delgamuuk, the court set out the test for evaluating Aboriginal title, but decided that there was not enough evidence in that case to establish the claim. So while the test was set out in Delgamuuk, it was only in 2014, in the case of Chilcotin, that the Supreme Court upheld a declaration of Aboriginal title for the first time. The Chilcotin Nation is a semi-nomadic group of 6 bands that share a common culture and history. For centuries, they have lived in central British Columbia. In 1983, British Columbia allowed logging in that area. The band tried to stop the logging, claiming Aboriginal title to the land. The federal and provincial governments opposed the claim. The trial judge found the Chilcotin had proved Aboriginal title, but the Court of Appeal reversed that decision. A unanimous Supreme Court agreed with the trial judge. What is important for you to remember is this. The Supreme Court said to look at the Aboriginal culture and practices and compare them in a culturally sensitive way with what is required at common law to establish title based on occupation. In other words, Aboriginal title must be understood by reference to both common law and Aboriginal perspectives. While the decisions in Calder, Delgamuuk, and Chilcotin acknowledged the relevance of Indigenous perspectives, they did not turn on Indigenous law. Recognizing the existence of Indigenous legal traditions is a relatively modern development in Canadian legal history. International law is also an important source in Canada. We can see this from the recent Nephson case, which was decided by the Supreme Court in 2020. As Professor Laforêt explained, the case involved 3 Eritrean workers. Their country has a national service program. All Eritreans have to do military training or other public service when they turn 18. They are often forced to continue that work for many years afterward. The 3 workers helped build a mine, which is partly owned by a Canadian company called Nephson. The workers sue Nephson for forced labor and other crimes against humanity. They said that those crimes were violations of customary international law and that Canadian courts should hold Nephson responsible. Nephson brought a motion to strike the proceedings. It argued that it could not be sued for violating customary international law. The Chamber's judge dismissed Nephson's motion to strike, and the Court of Appeal agreed. A majority of the Supreme Court also agreed. They explained that customary international law is the common law of the international legal system. They also explained that in Canada, we automatically incorporate customary international law into domestic law without any need for legislative action. This is known as the doctrine of adoption. The fact that customary international law is part of our common law means that it must be treated with the same respect. In Nephson, the court did not decide whether the company violated the workers' rights. That question was not before the court. The question was simply whether the workers' lawsuit could proceed. Since customary international law is part of Canadian common law, the court said that a Canadian company could be held responsible for violating it. As a result, the lawsuit could indeed proceed. And not to leave any of you hanging, I will tell you how that story ended. A few months after the Supreme Court decision, the parties settled. Journalists reported that Nephson agreed to pay an undisclosed, but I quote, significant amount of money to the workers. Nephson is one example of the application of international law within Canadian law. I will leave you to read up on the others. This brief overview of the Supreme Court's jurisprudence was not intended to be exhaustive. I could have given you many more examples from each source of law, but time does not allow. In the years ahead, the court will consider more cases like these. So there will be even more opportunities for dialogue between the different sources of law. Par le dialogue, nous sommes davantage en mesure de comprendre chacune de ces traditions juridiques ou sources de droit, et davantage aptes à reconnaître les occasions où une ou plusieurs d'entre elles permettent d'éclairer une question de droit. Autrement dit, il y a plus qu'une perspective susceptible d'aider à résoudre un problème juridique. Au cours des prochaines années, la common law et le droit civil, tout comme les traditions autochtones et le droit international, continueront d'évoluer. Certes, ces sources et ces traditions évolueront séparément, selon leurs propres besoins et leur propre contexte, mais elles évolueront également en raison de l'influence qu'elles ont les unes sur les autres. Thank you very much for your kind attention. Looking forward to answer some of your questions.
Wow. Hi, everybody. I wanted that to go on for another hour. I was really learning a lot of great stuff. I'm Professor Thompson, and I have the honor of moderating the next portion of this presentation. And I will be asking the Chief Justice questions that have been submitted by our students. And so we got a lot of them, and I wish that I could ask all of them. But I'll try my best, guys, okay? And this is so exciting. Okay. So, without further ado. Okay. Mr. Chief Justice,
Yes,
I feel like
Professor
Oprah Winfrey.
Thompson.
I was reading an editorial that you wrote, I think it was for the Hill Times, and it was about the independence of the judiciary. And it was nice to read because you talked about looking at your office window and seeing the sun on Parliament. But the most striking thing about it was the date. It was January 27th, 2020. And a lot changed very quickly after you published that. And so this sort of leads into the first question that we received from our students, which is this. So in the early days of the pandemic, we heard a lot about canceled hearings and the challenges that were faced by courts, counsel, the people involved in these disputes, the plaintiffs and the defendants. And nearly 2 years now into this pandemic, more than 2 years, reflecting back from your perspective, what has been the impact of the pandemic on our justice system, in particular with respect to access to justice? And if I could add my own little question, which is, are there any silver linings to it? Is there any sort of advantages that we've learned from this that we can carry on post-pandemic?
Well, thank you for that very important question. I think that the short answer is yes, there was a major impact. It was a terrible pandemic. It's not yet over, but I hope that the worst is behind us. But like any other areas in our society, the pandemic had a terrible impact on the judicial system. And on March 13, I think everything closed, including the courthouses in Canada, including the Supreme Court of Canada. The building was closed. And so I must say that I was, and I'm still very proud of the manner in which the judiciary, the judges, and the chief justices across the country have reacted, because they realized that it was urgent to turn around quickly and try to find ways to release decisions, the most urgent matters, like in family matters, for instance, alimonies, custody, in criminal matters, bail conditions, jury trial, and so on and so forth. And they were able to turn around to address the most urgent matters. Insofar as the court is concerned, of course, we had this technology, the new technology, for years, since the 1980s. And the problem is that lawyers would not use it.
I remember when I clerked, the lawyers from BC sometimes didn't come. They just argued on the screen.
But
it was rare.
maybe not enough to my taste, because it's a question of cost and a question of access to justice. But the real challenge was not so much with the Supreme Court or the appeal courts, but the real challenge of this pandemic was with the trial courts, where witnesses, clients, experts had to attend, and the criminal matter as well. Imagine jury trials, 12 people in the same room. That was a real problem. But the courts were able to address those issues quite quickly. But during the month of May of 2020, seeing the necessity of doing something, I, together with the Minister of Justice, Mr. Lametti, we set up a special committee to resume the work of the courts across the country. And we've decided to meet every month, and we've been meeting every month since then. My next meeting is tomorrow, and I will meet again with the other members of the committee. And this committee, the goal was to try to establish the best practices and the guidelines to allow the courts across the country to resume in a safe manner their operations. And it was very useful, very helpful, and it brought also amendments to the criminal code. I said, in the first meeting, I said to the Justice Minister, I said, Minister, the most urgent matter is in criminal law, in the jury trial. We have to amend the criminal code to facilitate, to adduce evidence without always the presence of the inmate or the accused. And amendments were made to the criminal code. So it was very, very useful. We continue to work. At first, it was to tackle the issue of the pandemic. But now we've decided to meet every month to try to address other problems in the justice system, like the delays, like problems with the most vulnerable people up north, for instance, or people having mental health issues, or having problem to have internet, to have access to the court. So to answer, it's a long answer to your question, but yes, the pandemic had a terrible impact on the justice system, but the silver lining you were referring to, there is a good side of this pandemic, is that we discovered that using technology could resolve some of the issues, of the problems. And maybe for the long run, I would hope that all the stakeholders in the justice system will continue to use that technology to support access to justice.
Yes, that was going to be my question. Do you think that some of these practices will extend long beyond?
I would hope so. I would hope so. Although I must tell you that I think it would be a mistake to go back to where we were. I think the justice system, even before the pandemic, was suffering because the governments in general, the elected officials did not invest as much as they should have in the justice system, not only in New Brunswick, in every province of the country, and in every country where the rule of law governs. Because government, invested in health, invested in education, and that's right, of course. But the justice system was the parent pauvre of the government for so many years. And now I think that governments understand that they must invest in legal aids, they must invest in technology, they must invest in judicial resources. And that's why I think that I'm more optimistic for the future.
Wonderful. Thank you. Okay. The next question has to do with something you spoke about, which was particularly of interest to me because I teach Aboriginal Title as part of first-year property, and a bunch of my students are here tonight, so I know it was thrilling for them to hear you talk about it too. The cases of Delgamuukw and Chilcotin. One of the things that struck me was when you were speaking about Indigenous legal traditions or Indigenous law. And this is another question that's been submitted, which is over the past year, we've of course witnessed the shocking discovery of unmarked graves at past residential schools and the legacy of Canada's residential school system. And the debate has always been around, but this has increased the debate, and it's increased awareness, I think, among Canadians who hadn't been forced to reconcile it with before. I always teach my students about the precarious role that the Supreme Court of Canada plays in reconciliation. It's a court that is a court of settler law, but asked to resolve disputes between Indigenous issues and settler law. And it's a real treat to have you here. And so the question here that's been asked of you is, what role do you see for the Supreme Court to play in the larger project of reconciliation?
Well, first of all, let me say that I would hope, regarding this terrible circumstances of the residential schools. I would hope that one day all the family of those children will learn what happened. So that we could turn the page on that important problem. And I think we'll be on the right track. I think we'll be able to do that. But I would hope that those families deserve an answer. On the role of the Supreme Court, as you mentioned, of course, we wait until we get the cases. We don't look for cases. So we have to wait until the proper case is before us to decide according to the facts, according to the evidence, according to the arguments, if there's a difficulty or an issue that needs to be resolved. I would say, and maybe wrongly, but I think it's rightly, I would say that the Supreme Court of Canada, for the last at least 35, 40 years, was able to use its power, in a way, to properly recognize the rights of Indigenous people when the case was brought before the court and when the evidence was there. And I think that we released several very important decisions. I mentioned just a few minutes ago, but there are many others, which is in line with the possibility for the court to reconcile the Indigenous people with the rest of the population. But we're not the elected officials. Parliament is there to legislate, and we're there to interpret the law. That doesn't mean that we have no role to play. I think we have one, and I think that we've shown for the last couple of years that we will play it.
And do you see a greater role for the Indigenous legal traditions that you spoke about? Because we haven't seen much of that yet, I think, in the actual case law.
Well, it's a work in progress. It's a work in progress. Just like eventually I would hope that an Indigenous judge would be on the Supreme Court. It's a work in progress. Time will tell. Time will help us. But, there are many, many signs of improvement. I'll give just an example. It's a small example, but when I was presented as Chief Justice back in 2018, I've made sure that for the first time, somebody from the Indigenous bar would be invited to my swearing-in ceremony. That was the first time that happened. Wow. And it's a symbol, of course, but for me it was important. Just like I insisted also to have high school students from both sides of the river, from Ontario and Quebec, 60 of them, to attend the swearing-in ceremony, to understand how it plays out. And after the ceremony, I answered their questions for an hour. So that's the future. That's our own future. That's important that for those people to understand how it works.
Yes, I agree. OK, maintenant, je vais essayer une question en français et je m'excuse pour mon accent affreuse. OK.
Il est formidable.
Vous êtes tellement gentil. OK. Alors, vous êtes ici en Canada Atlantique et comme vous le savez, par convention, le Canada Atlantique compte généralement un juge originaire de la région. Actuellement, c'est le juge Malcolm Rowe, qui est d'ailleurs la première Terre-Neuvienne et labradorienne à siéger à la Cour suprême. Avec la retraite de juge Moldaver, en réfléchissant à la composition de la Cour, quelle importance accordez-vous à la représentation régionale et aux conventions de représentation pour l'équilibre du fédéralisme? Est-il important de maintenir cette convention de représentation?
Merci pour votre question. Elle est d'autant plus pertinente que nous avons dans la salle le président du prochain comité de sélection du prochain juge.
Oui.
Alors, Mr. McLaughlin is there, so he will take notes. But no, seriously, I don't appoint judges. It's up to the Prime Minister to appoint the Supreme Court justices, and I'm sure that he will make the right choice and the right appointment, following the recommendation and the good work of Mr. McLaughlin. But save for, of course, the judges from, je ne sais pas pourquoi je parle en anglais, tu n'avais pas en français.
C'est parce que
Alors,
mon accent. Je comprends.
Alors, je voulais dire simplement que c'est pas moi qui donne les juges et donc mon rôle est simplement de consultation, puis suite aux représentations et au travail du comité de sélection, je suis sûr que le premier ministre va faire la bonne sélection. En ce qui me concerne, c'est sûr que, à part les 3 juges du Québec, j'en ai parlé tantôt, c'est important de maintenir ce contrat, finalement, qui a été conclu en 1875, d'avoir au moins quelques juges du Québec pour assurer la pérennité du droit civil à la Cour suprême. Quant au reste, je pense que c'est une bonne idée, mais c'est une idée que je dis, là, c'est une opinion. C'est pas à moi à décider ça, c'est au premier ministre à décider ça. Mais je pense que c'est une bonne idée de maintenir un équilibre de la représentativité à la Cour. J'ai toujours dit que pour maintenir la crédibilité des institutions, puis la Cour suprême est une institution importante du Canada, il faut que les gens puissent se reconnaître. C'est une question de crédibilité. Et une manière de se reconnaître dans les institutions, c'est de s'assurer que tout le pays puisse participer d'une manière ou d'une autre à la Cour. Et donc, d'avoir des représentants de différentes parties du Canada, je pense que c'est une excellente chose.
And what do you think about adding 3 more judges, all from Atlantica? No, I'm just kidding. Just joking. Okay, we're doing okay for time, Ed? Okay, great. I have another question, and this is obviously from some nerdy student who writes the following. Okay, former chief judges at times have made it a priority to seek consensus among the presiding judges of the Supreme Court, and we've seen that in the past. Justice McLaughlin was one, or Chief Justice McLaughlin, that seemed it was important, particularly on key constitutional questions. What is your perspective on the importance of consensus among justices of the court? Do you feel it's important when possible to have a united front, or is this not as much of a priority as ensuring that judges provide perhaps an option?
I share the opinion of consensus. I think we're trying every time that we discuss after a hearing, we try to get as much consensus as possible. But as I mentioned before, we're 9 different people coming from different regions, different cultures, different language, different experiences. And it's normal that we will not be always unanimous on every legal issue. I would be very concerned if we were. I would feel that I'm in China or Russia, and where they are always unanimous. So it's normal in our system to have a dissenting opinion, but we always work in trying to get as much consensus as possible. Certainly in the most important issues, dealing with human rights and constitutional issues. For instance, the carbon tax, which is not a tax, as you know. We tried to, it was a 7-2 decision on most of the issues, 6-3 on the others. The Vavilov case in administrative law, it was one of the first case after I became a chief. I said to my colleagues, the standard of review, administrative law, it's very confusing. There are a lot of critics, you know that. Dunsmuir had been released 12 years before. I said to my colleagues, and they agreed, we have to settle this. So we tried to find the cases. We found the cases. It was heard on 3 days. I appointed an amicus curiae, and we released a decision, which I think is 7-2 decision, which is a good majority. And I think it was the right thing to do. So there was a consensus. So that there be dissenting opinions, that's good. That's part of our DNA. We've decided in the Supreme Court, like other Supreme Court, like the UK Supreme Court, US Supreme Court, to allow judges to file dissenting opinions because we have the judicial independence, provided that the opinion is well-founded in their opinion, and as long as there's no abuses. So I think it's going well in Canada. And, you know, in civil law country like France and Belgium, in the same level as the Supreme Court, like Conseil constitutionnel de Belgique ou de France, they can sit at 13 people. Sometimes a decision will be taken 7 against 6, but there will be only one decision. They only release the majority decision. You never know, but it's normal that there are different opinions. In Canada, we've decided to be more transparent, I think, and to indicate which are the decision in which there is a dissent, but there's always a majority decision, whether it be 9-0, 7-2, 5-4. There's a majority, and that's the law. That's the way we work.
I think that from a law student's perspective, you're doing a good job compared to those House of Lords decisions where they have 15 concurring decisions by Lord Borthegest upon high. No one, so I think it's great. Okay. So I'd like to switch gears, and there's been a lot of career advice, career questions that the students submitted. So I wondered if I could ask you a few of those.
Sure.
The first one is a big one, which is, what was it like to be the administrator of Canada?
It was great.
Was that something you anticipated doing as your role of Chief Justice? And did you have any difficulty balancing the demands and expectations of both roles?
Not in my wildest dreams. I would never expected to act like that. But it was my responsibility. It was my duty according to the letter patent of 1947. Of course, whenever the position of Governor General is vacant, I have to be the Chief Justice of Canada becomes the administrator of the country. So when I got the call, I had my swearing-in ceremony the following day because the Queen had to approve my appointment. It was done in the morning, so I got it in the afternoon, and swearing-in happened in the late afternoon on a Saturday.
Did you talk to the Queen?
No,
Oh.
but I had no time for that. I'm sorry, just kidding. But I was not expecting that. But you know, it was a bit more work, I must say. You know, I had a court to run. I had the CJC keeps me quite busy, I must say, with the renewal that we're doing, the NGI also, and the Order of Canada. So, but it was comforting in a way. It was, I learned so much. First of all, I was able to give the Order of Canada on some of our most distinguished Canadians throughout the country with a ceremony at distance, of course. But it was a nice, always nice event. I received and I welcomed the ambassadors, a dozen ambassadors of countries, you know, to welcome them to Canada and provide the right message. I discovered the people at Privy Council, the ones who prepare legislation, and very able person, very distinguished people, and the people at Rideau Hall. I said when I was the following day, I said I want to speak to those people, and I spoke to them by remotely. There were about 150 people, and given the circumstances in which I had to take over, you know, they were. I told them that they were important to us, that they were doing a great job, that we were very proud, and if Canada had the reputation that we have, it's partly because of them. And I know that some of them were crying because they had a very difficult period before. So it was important for me to be able to speak to them. And so I discovered other positive aspects of Canada. We have a very strong civil service. And so I was very happy to learn about that.
Yes, I was very curious about this because in your speech, and I share this, you talked about the importance of our public institutions. So that must have been very special to be part of that and to experience that and to keep it going.
Yeah, and to make sure that people knows about it also. That's why it's in my effort as Chief Justice, I want to speak and I want to provide as much information as possible to the citizens of this country to learn about our institutions and essentially about the Supreme Court of Canada.
We're running out of time, but I really want to ask you, what were the Winnipeg hearings like?
Oh, it was great.
Well, you brought it up, so I would love
Yeah,
to
well,
hear
that's
about that.
one goal I had when I became chief. I said to myself, why don't we sit outside of Ottawa? You know, there are many people who cannot come to Ottawa. They don't know about the Supreme Court, so why don't we try that? So we've done it. And we went to Winnipeg 3 years ago. It was a great success, I must say. We went there for a week. We heard 2 cases, one French language issue, another one in criminal law. And the 9 of us, the 9 judges were there. We met the students in 9 different high schools. For 2 hours, they were asking us questions. We met with the general public at the Human Rights Museum in Winnipeg, which is a great museum. There were 600 people there and asking questions for us. We met with the indigenous people and the Métis people. And we met, of course, at the law faculty and at Robson. And it was great. People were lining up in the morning at 6:30 in the morning to have a chance to get into the courthouse, to hear the case, to attend the hearing. So for me, that means that there's a will, there's a need to be informed, to know about the court, to know how the court is working. And it was such a success. We were tired at the end of the week, the 9 of us, but we said we should do it again. So we're going to Quebec City in September next.
Oh, wow.
And we might come to New Brunswick.
I was going to say, put us on the schedule.
Absolutely. Well, it takes a lot of work to prepare.
Yes, I can
It takes
imagine.
at least a year, 2 years to prepare.
One more question, and this is really for the students. Mr. Chief Justice, what qualities do you feel a lawyer being called to the bar today, or next week, or next year should have? What values should our young lawyers who are coming up to the bar strive to represent? And what's most important, do you think, now? And I know you gave some context. I was gripped by what you were talking about with the Ukraine. But what is most important? What should our students think about as they're becoming lawyers in the next few years?
Well, you know, the law profession is a very, it's a privilege to be a lawyer. And first of all, I would tell the students or the young lawyers to trust their instinct, to have confidence in your means. Ayez confiance en vos moyens. Don't undermine the possibility that you have. Second, I would say try to do some pro bono work. Try to include in your profession some part of your work to do pro bono. You will grow yourself in doing that, and you will help others. Now, the law profession is a noble profession, and because you speak and you act for somebody else. So by definition, it's a very noble, and part of that nobility is to be able to do some pro bono work. So I would encourage every students and young lawyers to do that.
I think we're out of time, and this ends my portion of the presentation. So I'm going to turn it over to the crusty old dean.
Thank you so
And
much.
thank you.
Thanks, Jane, I think. Chief Justice Wagner, on behalf of UNB Law, I want you to know how grateful we are for your presence here this evening and for your thought-provoking lecture. I was particularly inspired by the theme of dialogue between different legal traditions and perspectives as a means of judicial decision-making. I think this isn't just important as a matter of methodology, but it also allows the rule of law to be a beacon for conflict resolution more generally, as you suggested at the beginning of your lecture, and even interpersonal relations, because it's fundamentally about being open to different points of view. And that's a value that we hold dear at UNB Law, that we try to instill in our students, and that your lecture so eloquently reinforced this evening. Chief Justice, these trips aren't easy, especially during a pandemic, and you have many demands on your time. Ce fut un honneur de vous avoir comme notre invité, et j'espère que vous avez ressenti la chaleur de notre communauté. Merci beaucoup. I'd like to now call on the co-editors-in-chief of the UNB Law Journal, Julio Hanley and Graham Hebert, to come to the stage and present a gift to Chief Justice Wagner.
Thank you so much, Chief Justice, for coming to Fredericton today to deliver this wonderful speech to all of us. And thank you as well to your involvement with the upcoming edition of the UNB Law Journal. We really appreciate you agreeing to do that for us. And so on behalf of the UNB Law Journal, we would like to ask you to accept this gift.
Thank you so much.
Wonderful.
Thank you very much. Thank you.
Now, before we end for the evening, I'd like to thank the people who contributed to this event. First, I'd like to thank Chief Justice Wagner's staff, especially Executive Legal Officer René Thériault, who's a native New Brunswicker and who worked with us so closely for several years and was committed to this event despite the shutdowns and everything that was happening with the pandemic. Thank you very much, René. Thank you to Professor Laforêt, who pounced to make this invitation as soon as Chief Justice Wagner was appointed. This lecture would not have happened without you. Thank you very much, Anne. Thank you as well to Professor Thompson for hosting the question period and not going too much off script, so that's, that was pretty good. Thank you as well to Julia and Graham, who, as they mentioned, are working on a special issue of the UNB Law Journal based on Chief Justice Wagner's lecture, and there'll be submissions and articles in that volume that draw on many of the themes in the Chief Justice's lecture. So look forward to that. I also want to thank our wonderful staff at the faculty. Pretty much every staff member in our faculty was involved in one way or another in organizing this event. And if I have to single one person out, it would be Ed Bose, our public engagement officer, who managed all of the logistics for this event. And pulling this off during the pandemic is no small feat, and Ed did a fantastic job. And thank you to everyone who came tonight here in person and to everyone watching on the internet. It's been wonderful to have this event and to welcome everyone back to the law school for a Viscount Bennett lecture. Would you please rise and remain in your places for the departure of the Lieutenant Governor? Thank you very much, everyone. That brings our evening to a close.